Thanks again for jumping on for our webinar this week on stop chasing unpaid invoices, payment terms that actually work for you. My name is Nick. I'm one of the legal solutions consultants here at LegalVision, and today I have two co-hosts. We've got Vanessa Swain from LegalVision, who's one of our practice leaders in the disputes and litigation team here. And we've also got Hayley Alderton, who is one of the practice leaders here in our commercial and regulatory team. Vanessa and Hayley, would you like to quickly introduce yourself, starting with yourself, Vanessa?
Sure. Hi, guys. My name's Vanessa. As Nick said, I'm a practice leader in the disputes team. I've been at LegalVision for just under 10 years now and do a lot of work with clients in relation to debt recovery and these types of things.
Thanks, Nick. Yes, I'm a practice leader in the commercial and regulatory team. A much shorter tenure here at LegalVision than Vanessa. I've been here 6 months, but preceding that, I have been in-house across both private sector and government.
Awesome. Well, thank you both for introducing yourselves. Good to have you on. Now, before we get started today, just a couple of quick housekeeping items as per the slide on the screen. You will receive the recording and the slides of today's presentation after we've concluded. So if there is anything you wanted to check back, you will have that in your inbox. Please, at the bottom of your screen, there will be a Q&A box. If you have any questions that arise as we're proceeding through the presentation, feel free to just pop them in there. If we can get through them at the end, we will answer them. However, if we don't, we can always get back to you about that after the presentation concludes. And then also after the webinar has finalized, you will receive a feedback survey. And if you could please provide us with some information and feedback on that, that'd be great, so that we can ensure we're still providing some great value to you in these webinars. By viewing this webinar, you are eligible to receive a complimentary consultation with LegalVision to discuss how we can help your business. So to claim this consultation, leave your contact details in the survey that appears when the webinar ends, or you can contact us via our website and just let us know you attended the webinar, and one of the team will be in touch to book that in for you. Now, before we jump into the agenda and before I pass over to Hayley, who's going to introduce that, we do have a poll question that should have popped up on each of your screens. Today, the poll question is, which aspect of unpaid invoice management do you find most challenging? Now, Vanessa and Hayley will touch base on the answers and discuss that at the back end of the call. But for now, Hayley, I'll pass over to you.
I think in relation to the poll questions, Vanessa, were you able to see those?
Yes, I can. We'll get the results shortly, Hayley, and we can report on that. So if you want to go through the agenda.
Okay, sure. Okay, so as you can see on your screen, we're going through a range of topics, so I'm on the front end where I'm talking about the clear and enforceable payment terms. We're looking at advanced protection strategies, then legal deterrents and best practice contract strategies. We then turn to Vanessa, who will be talking about communication and letters of demand. We'll be talking about assessing debt recovery viability, statutory demands and court proceedings, enforcing court judgments, and then we'll turn to key takeaways and we'll do a bit of a Q&A.
Okay, so we've got the poll results in, so let's just run through those super quickly. So the majority of people have indicated that all of those items were important to them and they're just here to learn as much as they can today, with the other two main pertinent issues being learning how to set clear and enforceable payment terms and managing the debt recovery process. So we'll touch on all of those as we go through this presentation today. So to start off with, I just wanted to provide some context in terms of why debt recovery is important to businesses, and the impact it can have on your business. So to start off with, 40% of small businesses spend over 12 days per year chasing unpaid invoices, which is a significant drain on resources. A majority of businesses have reported facing issues with late or unpaid invoice in the previous year, with 38% having to delay their own payments as a result. Over 2/3 have reported problems caused by suppliers extending or ignoring agreed payment terms. And a whopping 25% of more small businesses have reported that their cash flow situation is so precarious that they could not survive a month if invoices remained unpaid. These statistics really highlight the major cash flow challenges and financial burdens that small businesses face due to late payments and unpaid invoices. Effective debt recovery processes are crucial to alleviating these issues, improving cash flow, maintaining supplier relationships, and supporting the sustainability and growth of small enterprises.
In good news, these issues are largely preventable through well-structured payment terms and contracts. You can build your contracts to protect your payment and cash flows while remaining commercially attractive. We understand that's very important. You can't have overly aggressive contracts because then you have no customers. Ideally, you are setting clear terms and communicating those terms to your customers to avoid mismatched expectations. Firstly, you should be setting out clear invoicing dates. When does your business send its invoices and how will your services be charged? For instance, are you looking at charging a fixed fee or on a time spent basis? Then you should consider whether your payment triggers are clear enough. Your contract should set out the events or milestones that will trigger the payment, such as the delivery of goods, the completion of a project phase, or specific pay dates. Your payment terms should be bespoke and tailored to your business practices and the way you charge. The most effective way to secure payment overall is simply to request it up front. When a client pays before receiving services or goods, of course, it removes the risk of non-payment. However, of course, this is not always feasible, especially in business-to-business circumstances where customers have greater leverage and use that to seek flexibility over the payment terms. So where it's not feasible to receive upfront payments, you should consider receiving or requesting a deposit to cover part of the payment. If a client, for longer or larger contracts, you can also request interval payments that allow you to receive partial payments for work completed so far. If a client defaults later, you will at least have received some payment for the services or goods already delivered. Where we see some issues come up is where there are vague terms like payment within reasonable time or within 30 days without specifying within 30 days of what. Are your enemy here? Instead, you should be specific. Payment due within 30 days of the invoice date, or payment due by the 15th of each month. 50% deposit required before the commencement date are just some examples of more specific terms. I have seen an example recently where we've had a client who had a very small deposit, and then later along the line, after their customer has received the goods, the payment terms were after the customer completed their project, the goods were being inputted into a broader system. That really exposed that client to delays in the project on the customer side that were outside of our client's control. So we've instead worked with them to have a more substantial upfront deposit and then payment upon delivery instead, so that they're not exposed to waiting up to a year in some circumstances for delays in their customers' project timeframes. Lastly, on the payment term side, you should also consider whether you have incorporated all of the costs and charges that you're expecting to pass through. You really need to think through this at the start while you are negotiating your contracts and thinking about everything that you might be charged that you want to pass through reasonably to your customers. That will assist the process so that you're not issuing a shock invoice to your customers and they know what's coming, because then, that's obviously putting them offside and they might be heavily scrutinizing what you're charging them. And that just makes it more challenging when you are going to enforce your payment terms. Okay, now I'll be talking about some advanced protection strategies. Firstly, we're looking at personal guarantees. So when dealing with companies, especially new or smaller entities, personal guarantees from directors can be invaluable. They create personal liability for business debts, significantly increasing your collection prospects. However, they do need to be used strategically, and they can be a deal breaker in competitive situations, and they may be too heavy-handed. Now turning to retention of title, this is more relevant to goods suppliers. Retention of title clauses are crucial. You maintain ownership of goods until full payment is received. This means if your customer becomes insolvent, you can reclaim your goods after delivery from them rather than joining a queue of unsecured creditors. So if you are selling, hiring, or leasing goods, you should consider including a clause under there's federal legislation called the Personal Property Securities Act. This clause would specify that the customer must provide you with the necessary information for registering your security interest in the goods on a register, which is called the Personal Property Securities Register, or PPSR. And you can also search that register for a very small fee, and you can see what securities are registered over other companies. So it can be useful to also check that. Okay, now I'm turning to set-off rights. Set-off rights allow you to offset amounts that you owe to a customer against the amounts that they owe you. So this can work best in ongoing commercial relationships where there are mutual debts, payments flowing both ways. However, it's just important to note that if you're the one supplying the goods or services, you should be aware of the existence of this clause because it can be used by a customer to reduce amounts that they would otherwise owe you, for example, for defective goods. The clause sounds something like this. You agree that we may set off or deduct from any monies payable to you under this agreement, any amounts which are payable by you to us, whether under this agreement or otherwise. Sounds a little bit like legal jargon, but yeah, it's just about netting off amounts payable. They can get a little bit complicated. It should be drafted quite narrow and specific so that it doesn't have unintended consequences. Now turning to late fees. There were quite a few questions about late fees, so looking forward to delving into this. Late fees are great at motivating prompt payment. Well-structured late fees serve a dual purpose. They compensate you for collection costs and they motivate prompt payment. If you have not included details of the late fee in the contract, then you can't choose to add it on at a later date. You must also navigate the Australian Consumer Law's unfair contract term provisions. The key in ensuring late payment clauses are enforceable include the following. It should be a genuine estimate of your loss or administrative costs, not just a punishment. It must be reasonable in the circumstances and it must not be disproportionate to the breach. If a late payment fee is excessive or unreasonable, then the client may refuse to pay. Including an exorbitant late fee in your contract is known as a penalty clause and is unenforceable in an Australian court and may attract penalties. For example, examples of loss due to late payment include the additional time taken to chase up the payment, which is obviously a cost to your business, or the cost of paying outside help such as lawyers or debt recovery agents. So the actual amounts that you can charge for your late payment fees are very contextual. Just to provide an example, think of a business running a monthly food delivery subscription and they bill their client after they've made a delivery. If the client does not pay by the date stated on the invoice, then they will incur a $5 per week late fee. This fee is to cover the cost of the additional administration required to follow up on the late payment. This is likely to be determined as fair and reasonable. However, if you looked at another business who was charging at $50 every day because they really want them to pay, that payment is most likely going to be viewed as a punishment and therefore would not be enforceable in court. Lastly, as some further practices to consider, you can consider differing payment terms for different customers and tailor it accordingly. If you have really good long-standing customers with good payment histories, you can offer preferred terms to them that are a bit more relaxed while maintaining stricter terms for new or high-risk customers. You can consider early payment discounts rather than just trying to rely on penalties for late payment or late fees. And you can also ensure your sales team explains payment terms during negotiations, not just after contract signing, so that both parties have aligned their expectations about the arrangements. And lastly, we always recommend undertaking due diligence on clients in that B2B setting. You can look at things like creditworthiness and financial stability and adjust payment terms according to any red flags that you may identify. Okay, now I'll turn over to Vanessa.
Thanks, Hayley. So now let's take a look at what happens when your debtor fails to pay an invoice on time. When invoices become overdue, it's always helpful to begin with a friendly email reminder to your debtor. This initial approach is particularly important when you're trying to maintain ongoing business relationships, which is the case in so many scenarios. These initial reminder emails are quite ideal candidates for automation, which can also significantly reduce your administrative time spent chasing payments. It can also be beneficial to give your debtor a call to find out why payment has not yet been made. Open communication is always helpful in these initial stages. However, if a debtor continues to ignore payment obligations despite initial reminders and follow-ups, the next logical step is issuing a formal letter of demand. This represents a more serious escalation in the debt recovery process. So a well-crafted letter of demand serves two main purposes. Firstly, it can prompt immediate action from the debtor. And if necessary, it also provides crucial documentation for potential legal proceedings down the track, should that become necessary. There are a couple of essential elements that should be included in any good letter of demand. Firstly, it's important to ensure that you have the debtor's correct legal name and current address, as well as their ACN or ABN. This is particularly important, and I've seen time and time again where demands have been sent to wrong entities. So it's really important and crucial to get that bit right. It's important to also make clear what invoices you're chasing. Include details of the invoice numbers and dates and the total amount owed to you. It's also helpful to attach a copy of the outstanding invoices, or if there's lots of them, you could alternatively include a statement of account. Your letter must include a clear and unambiguous demand for payment with a specific deadline. So the deadline is generally 7 or 14 days, but can be structured dependent on your circumstances. Remember that you need to provide details of how the debtor can make payment. Once again, I've seen many letters be issued where parties or creditors have demanded payment, but not provided the details of how they can make the payment, which causes a further delay. So remember to include any payment methods, bank account details, and any reference numbers that should be quoted. The general gist is make it as easy as possible for them to make payment to you. Also, you need to clearly outline what will happen if payment isn't received by the deadline. So this could include a threat of legal action or additional charges or potential credit reporting impacts. It's best practice to send a letter of demand via a trackable delivery method to ensure you have proof of receipt. So this could be done, for example, via express post. Letters of demand can also, of course, be sent via email, which is becoming more and more popular, particularly if you have a history of communicating with your debtor via email. Before escalating your debt recovery further, it's really important to conduct a thorough assessment of the viability of your debt recovery across three main critical areas. So firstly, conduct a cost benefit analysis. So debt recovery, as a lot of you are no doubt aware, can become a time-intensive and expensive process, especially when it escalates to formal legal action. So you need to carefully weigh the outstanding debt amount against potential recovery costs, including legal fees, court costs, and the value of your staff time that will be dedicated to the matter. Ultimately, for smaller debts, the total expenses involved may actually exceed the potential recovery amount, making pursuit financially unviable. Secondly, we should also be assessing whether the debtor actually has the financial means to pay the debt. Pursuing debt from an insolvent entity is typically futile and represents a poor use of resources in most instances. You can try and undertake and conduct proper due diligence on the debtor's current financial situation as best you can to help you determine the realistic likelihood of successful recovery. I say to clients time and time again, you cannot get money from that doesn't exist. So same as you can't get blood from a stone, you can't get money from an empty account. Finally, you should also consider the strength of your evidence. To successfully recover a debt, you must have solid documentation and evidence to support your claim. So this includes things like written contracts, invoices, delivery receipts, email correspondence, or any other record that establishes the existence and validity of the debt. Without proper documentation, it can prove challenging to ultimately prove your case in court or negotiate a favourable settlement. Ultimately, though, if the outstanding debt is substantial, the debtor appears to have the means to pay, and you have strong evidence to support your claim, it may be worth pursuing recovery through legal channels. However, on the flip side, if the debt is relatively small, the debtor is insolvent, or you lack adequate documentation, it may ultimately be more practical to write off the debt and focus your efforts on more promising opportunities. If your debtor has failed to comply with your letter of demand and you've undertaken the assessment process and you've assessed that recovery is likely viable, your next step will likely be to engage a debt collection agency or lawyers to assist you. If engaging a lawyer, you have two main formal recovery options. The first is issuing a statutory demand, and the other is initiating legal proceedings, both of which we'll talk about in a little more detail. So starting with the statutory demand, the statutory demand is a formal legal document, so it's quite different to a letter of demand, and it's something that creditors in Australia can issue to company debtors. So it's only available where the debt is owed by a company. It's a powerful tool that can compel debtors to pay outstanding debts or otherwise face insolvency proceedings. So there are a couple of conditions that must be met before a statutory demand can be issued. So firstly, the debt owed must be an undisputed liquidated sum. So this is generally unpaid invoices for goods or services that have been supplied, most commonly. Secondly, the debt must exceed the statutory minimum threshold. Now that threshold currently is $4,000, so not a huge amount. And thirdly, the debt must be due and payable at the time of issuing the demand. So you can't issue a demand when there's still, when your invoice terms or payment terms have not yet expired. The statutory demand I generally find is a good option in circumstances where a debtor has repeatedly failed to respond to previous payment demands or reminders, and is also a good option where you have strong evidence and documentation to support the existence and validity of the debt that you're claiming. If you believe the debtor has financial means to pay the outstanding amount and you want to demonstrate that you have a serious intention to pursue legal action if the debt remains unpaid, this is also a good option to consider. There are a couple of specific legal requirements that a statutory demand must meet. These include that the statutory demand must be in the prescribed form and it must be properly addressed to the debtor. It must clearly state the amount of the debt and the creditor's intention to commence winding up proceedings if the debt is not paid within the specified time. The specified time for statutory demands is 21 days, and there can be no extensions beyond that time frame. A statutory demand must provide instructions to the debtor on how they can comply with the demand or otherwise apply to have it set aside. And it must be served on the debtor in accordance with relevant legal requirements. So generally, this is by sending via prepaid post to the debtor's company registered address, or alternatively, you could attend to personal service on a director. Ultimately, if the debtor fails to comply with a statutory demand within the specified 21 days or fails to take steps to have the statutory demand set aside, a presumption of insolvency is automatically created, which you can then rely on to commence winding up proceedings, which might ultimately result in the debtor company being placed into liquidation. So there's some pretty serious consequences to not complying with a statutory demand. So let's take a look at the steps involved in the litigation process. Firstly, the first step is to file a statement of claim if the debt remains unpaid after a letter of demand has expired. The statement of claim will outline the legal basis of your claim, details of the debt owed, and the relief being sought. So in most instances, that will be payment of the debt amount plus payment of an element of interest and legal costs usually as well. The statement of claim needs to be served on the debtor, so typically by post to the company's registered address, or if you are commencing recovery against an individual, you'll require personal service of the statement of claim. Once served, the debtor has a specified time frame to comply, to file their defence, which is generally 28 days. If they fail to do so, the creditor can then make an application for default judgment and proceed with enforcement action, which we'll talk about in just a second. However, if the debtor disputes the claim by filing a defence, the proceedings naturally progress to a defended hearing pursuant to the orders and directions of the court, with both parties presenting evidence and legal arguments and the court ultimately determining the final outcome. So as I said, if the creditor is ultimately successful and the court issues a judgment in their favour, you can take steps to enforce that judgment debt if required. In many instances, it will be necessary to take some form of enforcement action. Usually if debtors have failed to make payment up to this point, having judgment entered against them will not automatically guarantee you payment straight away. So there are a number of enforcement options that creditors can pursue. Firstly, there's a garnishee order, and this is a court order which directs a third party, commonly the debtor's employer or bank, to pay portions of their income or funds held in their bank account directly to you. The second main enforcement option is a writ of execution, which allows the sheriff to attend to the debtor's premises for the purpose of seizing and selling the debtor's assets in order to recover the debt amount. A writ of execution is often a good option for the smaller debts, smaller judgment debts, not necessarily a great option for a larger debt unless you're aware of some specific high value assets that the debtor may own. For substantial debts, you also have the option to proceed with bankruptcy proceedings against individuals or winding up proceedings against companies. Over to you, Hayley.
Had myself on mute. Thanks, Vanessa. Key takeaways. As we've touched on, unpaid debts can have a significant impact on your business and so should be taken seriously. Make sure you have proactive prevention strategies in place. For example, prompt invoicing, clear, executed contracts, and client communications. Be ready to escalate your debt recovery claims where appropriate. As Vanessa's just set out, a range of enforcement actions that you could take, but always be aware of the cost-benefit analysis before embarking on a legal claim. You don't want to throw good money away after bad. And then lastly, consider getting legal advice to ensure you have your client agreements in line and when you need advice on whether or not to pursue a claim. So now turning to the next slide.
Alrighty, you got me back. Loud and clear. Thank you, Hayley and Vanessa, for running us through all of those slides. Lots of good information there and lots to think about. And as we mentioned, we will be setting these through after. That concludes the main part of the webinar. Please do stick around because we will be answering some Q&As that have been sent through during the presentation. One thing that we do have, or we like to share, is we put together a publication, How to Recover Unpaid Invoices, a bit of a resource that you can also refer to that touches on some of the information we discussed today. So you can scan the QR code on the screen to retrieve that. As I mentioned, these will be sent through as well. Before we get to the Q&A, we do have our next webinar coming up in 2 days' time. That is on managing psychosocial risks, employer and legal counsel responsibilities. That's at 11 a.m. again, however, on Thursday. And you can follow the link that's on the screen, but you can also check our website where that is all listed. And then lastly, as we've touched on with claim the consultation, we have our LegalVision membership on offer. And basically what that is by becoming a LegalVision member, you get unlimited access to our full team of over 100 specialist lawyers. For all of your business as usual legal needs. It's like having your own in-house counsel, but for a fraction of the cost. Our team can assist you with unlimited documentation, drafting, reviewing of business contracts and other bespoke documents. You do get unlimited legal advice consultations and, importantly, unlimited domestic trademark registrations and much more, with options to purchase extra credit towards complex matters and ongoing disputes, which are charged on hourly rates basis. So as a LegalVision member, you don't need to worry about the cost of lawyers. Think of it as having your own in-house legal counsel. We'll take care of the business as usual legal work so you can focus on running your business. We also offer a dedicated service for in-house teams and general counsel to manage your high volume business as usual legal tasks. Our lawyers invest upfront in understanding what's important to your business and work as an extension of your in-house legal function. Certainly, if you want to learn more about the membership or our desk extension offering, request that free consultation when the survey appears, and one of the team will be in touch to run you through all of that. But as mentioned, we will now move on to answering some questions from the Q&A. Some of them were submitted before the presentation. So Hayley and Vanessa, did you want to jump through a few of those together?
Yeah, thank you, Nick. So one of the questions that was pre-submitted prior to this webinar was, can a customer refuse to pay an unpaid invoice if it has been outstanding for a length of time? And if so, what is the length of time? So the short answer here is no. Customers cannot simply refuse to pay because an invoice is old. However, there are some limitation periods that affect your ability to recover debts through court action. And in most Australian states, that limitation period for debt recovery is 6 years from when the debt becomes due and payable. There's still options to take action after the 6 years, but the debtor can raise a statute of limitations defence in court proceedings, and when you may need to seek leave from the court. If you're approaching a limitation period, so if you're getting close to that 6-year limitation period, you should be giving real thought as to whether you want to be commencing or considering formal legal action to preserve your rights.
I'll take a question now. So I had a couple of questions that really go to the enforceability of contracts. The question was, can small businesses enforce their own terms and conditions with payment terms, including late fees, when the client they are working for insists on a service agreement and doesn't take into account these things? And a similar nature question that's come through live was, let me just find it. Yeah, many of my late invoice payments are from small companies that I do not have a contract with. Can these steps still be implemented but detailed on the invoice instead of in a contract? So it's really important to be clear what the parties agree. This, absolutely ideally should be in a written executed contract. In the first question, where the other party is insisting on using their template service agreement and the person asking wants to enforce their own terms and conditions, if you sign the service agreement, your terms and conditions will not apply. So if there's something really important to you in your own terms and conditions, you do have to negotiate them into the document that you're agreeing to. If it happens quite a bit, like due to negotiating power, a larger entity is going to insist on using their own paper to enter into an agreement. So it can be challenging. But yeah, unfortunately, if the other party hasn't signed on to your terms, then you will face challenges trying to enforce that.
Okay, I can see one of the questions that has been submitted. Is it legally compromising to place a caveat to protect any avoidance of payment of invoices? We get this question quite a lot. And the short answer is having an unpaid invoice does not grant you the right or ability to lodge a caveat over someone's property. In order to lodge a caveat, you need to have a caveatable interest, and that is a form of security over or relating to that specific property. So in short, you should not be lodging caveats over properties in relation to unpaid invoices unless you have a proper and enforceable caveatable interest. That's something quite complex and is something that you should be speaking to a lawyer about before you commence or take steps to lodge a caveat, because there are some flow-on ramifications that can flow from that if a caveat has been lodged improperly. What other questions have we got, Hayley?
I've touched on this one a little bit in the last one. We had a question, a few questions like this actually, how to get corporate entities to pay on my terms, not theirs. Specific reference to large supermarket chains. Yeah, very difficult for large organizations. Generally, you'll be on their terms. It's quite often take it or leave it. They don't tend to afford smaller suppliers much flexibility. They also, often have some reasons behind that. They process payments all together in big lumps. But yeah, in that circumstance, if you are wanting to contract with those very large entities and supply to them, then unfortunately it can be challenging. I saw in a similar vein, someone submitted a live question about how would you get the CEO or director of Woolworths to sign the director guarantee? No one from government is signing these either. Biggest corporations set the payment terms. My small business does not have the leverage. Agree with that last sentiment as well. It would be, well, we wouldn't expect to see a CEO or director signing a director guarantee that exposes them to personal liability in those circumstances. So in relation to a lot of the contractual front-end protections, you do need to consider the negotiating power that you have. Once you, as I mentioned in the presentation, once you enter into those kind of B2B contexts, you might encounter those circumstances where a large entity is very firm on its terms and conditions. And you will face challenges trying to get your terms and conditions, and may not be worth the effort sometimes in trying to negotiate that, but yeah. Okay, over back to you, Vanessa.
Sure, thank you. So we've also got a couple of questions about around how do you balance compassion with cash flow, or how to action recovery with vulnerable customers or customers with mental health issues. So this is a great question. And my recommendation here would be to take a sensitive and graduated approach while still protecting your business interests. So there's a couple of things that you can do. So if you become aware of mental health issues, you should be documenting it and taking a considered approach on how you're going to move forward. You can start with more gentler communications. You can offer payment terms or payment plan options. And you should keep detailed records of any interactions that you have with these individuals, as well as any accommodations that you may be offering to accommodate their needs. You should absolutely be considering whether these vulnerable people have a support person or a guardian or an advocate that you should be communicating with rather than through them directly. And if they don't have a support person in place, you can also try referring them to there's a number of free financial counselling services that can assist people with these vulnerabilities. So that's a good course of action as well. As I said, consider offering payment plans rather than demanding the full amount, but also set some clear boundaries, because compassion here doesn't necessarily mean writing off legitimate debts. It's about working with them rather than conceding and not getting payment at all. I think we've got time maybe for one more question, Hayley.
Sure. I have two similar questions, and they are about contracting with overseas parties. So please apply to situations where we are contracting with overseas parties. What are effective, realistic protection and deterrence strategies? Recovery, as this person has flagged, overseas recovery is costly and extremely challenging when you're looking at international jurisdictions. And someone else says, what if the client is abroad? Yes, so this is very contextual as well. Depends on the types of goods and services that you're providing. One option would be suspending services or supply. If they're quite dependent on you, then that might prompt them to come up to date with their payments. But here, really, the most effective risk mitigation is to secure a large proportion, as much as you can, as an upfront payment. That kind of goes back to that supply of goods example I provided earlier, where that client was finding themselves out of pocket for up to a year waiting for an offshore party to complete their project. So to the extent that you can have really clear payment terms and more paid upfront, then you'll find yourself mitigating that risk.
Alrighty, well, thank you, Hayley and Vanessa, for answering those questions and again for the presentation. That's all we have time for today. So sorry if we didn't get to your question, but as we mentioned, there will be that feedback survey at the end. When that pops up, yeah, feel free to put any questions in there that we didn't get a chance to answer. Of course, if you would like to learn more about the membership that I discussed earlier, then please request that in there as well, and we'll be in touch to book you in. And also, whilst this webinar is free, please, if you can provide us with some feedback, that would be great to ensure that we're providing as much value to you in these webinars as possible. And that's all for now. So thank you for joining us, and we'll see you next time.